welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about one of our 8 goals of a good estate plan. And the goal we're going to talk about today is avoiding a probate case when you pass away. If you want to learn more about the other goals of a good estate plan, you can go to learn-about-law.com, where we have podcasts and video blogs and articles on each of the 8 goals explaining what the goals are and how an estate plan can be used to accomplish those goals. But today we're going to talk about what probate is, how we can avoid it, and why we want to avoid it. So let's start with what probate is. Probate is a court case that happens when you pass away that gives your executor the power and the ability to distribute your assets to your heirs and to creditors. And if probate is necessary in your case, then in order to get the power to actually collect your estate assets, liquidate them, sell your house, get access to your bank accounts, and then pay off your creditors, distribute the rest to your beneficiaries, they would need to open up a probate case and be formally named your executor. They get something called letters of office, which is an order that's from the court giving them the powers of executor. And if probate is necessary, then in order to get these powers, they have to have these letters of office that they take around that gives them the power to liquidate the estate. And if probate is necessary, then the probate court oversees your executor's distribution of the estate to creditors and heirs. So let's talk about why probate is bad. It's something that's avoidable with a good estate plan, so we want to talk about why we want to actually avoid probate. Probate's bad for 3 reasons. The first is that it takes about a year. And during that year, your loved ones don't have access to your assets. They don't get access until they're distributed at the end of the probate case. So it takes about a year because there's a 6-month period after the filing of the case where creditors have the ability to file claims against the estate. And the estate has to be left open. Nothing can really be distributed during those 6 months. After those 6 months pass, it takes the executor another several months to actually wind up the estate. So when we file a petition for probate and have your loved one appointed as the executor, at that initial court hearing, we'll set a court date for about a year out for closing the estate because we assume that it's going to take about a year. And then during that time, your assets are tied up in the probate case and your loved ones can't get access to them. If probate isn't necessary, your loved ones can have immediate access to your assets. And we want them to have immediate access to your assets because if you're the breadwinner and your spouse can't afford the mortgage anymore and needs to sell the house, she needs the ability to do that right away. Or if your kids need the assets to pay for schooling, they usually can't wait a year to do that. So that's why we want to avoid a probate case. Number 2, the second reason we want to avoid a probate case is because it's expensive. We're pretty proud of our rates that we charge for our probate work. We charge an hourly rate, but most attorneys don't. Most attorneys charge 5 to 10% of the value of the estate, depending on the level of complexity. And usually at the closing of the estate, the attorney's just awarded this amount by the court from the estate assets. So that's almost like a tax on your estate. That's 5 to 10% of the value of your estate that's not going to your loved ones, but it's going to the attorney. There's also filing fees involved with filing the probate case that are expensive. That's a couple $100. There's publication fees to publish a notice of the probate case in a newspaper. So those costs start to add up. So between attorney's fees and other costs, that's a lot of money that could be going to your loved ones that isn't. So even if you've got a small estate, even if there's only $50,000, you'd rather not pay a big chunk of that to an attorney, even if it's 10% of $50,000. So number 3, the third reason it's bad, is that it's a major headache for your executor. There's a joke in probate circles that basically if you have a terrible enemy, what you should do is make them the executor of your estate because it's such a pain in the butt for them to deal with. And it's a pain, as you'd imagine, anytime you're dealing with a year-long court case where you're working with an attorney, filing reports, preparing notices, appearing in court a couple times. At a time when your executor wants to be focusing on your family and not on a court case, they're drawn away from that, and the stress of the loss they're already experiencing is compounded by having to deal with probate. So again, to recap, probate's bad for 3 reasons. It ties up your assets for about a year and your loved ones can't get access to them, costs about 5 to 10% of the estate in attorney's fees, and it's a major headache for your executor. So we've established that we want to avoid probate. But when is probate necessary and how do we avoid it? Probate is necessary in Illinois in a couple different situations. whenever you own real estate outside of a trust or without a right of joint survivorship on the deed, probate is necessary. So I want to dig into this. Anytime a married couple owns real estate, it's typically with a right of joint survivorship right into the deed. So it's Mary and John own this piece of land as joint tenants with right of survivorship. That's what your deed will say. And that's fine. And when Mary passes away, John can get that piece of real estate without it having to go through a probate case. But the problem is if they have kids and John passes away after Mary, then the real estate's going to have to go through probate if it's not owned by a trust. Or if something happens to them both at the same time. So, again, the rule for real estate is any real estate outside of a trust or outside of a joint survivorship situation triggers a probate case. And something that most people don't know is that a timeshare qualifies as real estate. Condos that you live in qualify as real estate. Even if there's a mortgage on the property, even if the property is underwater with the mortgage, if there's real estate outside of a trust and outside of joint survivorship, probate is necessary. The other situation in which probate will be necessary in Illinois is if you own more than $100,000 of non-real estate assets outside of a trust or outside of payable on death accounts with a living beneficiary. So, again, let's dig into that a little bit. You can transfer your major savings accounts to a revocable living trust, and as long as you've got less than $100,000 outside of the trust and no real estate outside of the trust, then probate can be avoided. The other thing that some people do, and I don't usually recommend it, is they take those major accounts and make them transfer on death. So you change the title of the account to make it automatically pass on death to some specific person. The problem with that is that if that beneficiary predeceases you, isn't living when you pass away, then that account's going to get dumped into your probate estate, and probate's going to be necessary. The other problem with that is you better make sure that all of your accounts have that title, and if they don't, if one or two slip through the cracks, then it's going to trigger a probate case. So, again, what we typically do is make sure that you have a revocable living trust in place and you transfer your real estate to the trust through a deed and your major savings accounts through just changing the title of the accounts. And, we don't usually rely on joint survivorship for the real estate and payable on death situations for the accounts. And so if as long as there's no real estate outside of a trust when you pass away, less than $100,000 outside of the trust, then probate won't be necessary. And we'll talk in just a minute about what happens when probate isn't necessary and how the estate is dealt with. But let's now kind of shift gears to what revocable living trusts are and how they work. So a revocable living trust is a legal entity other than yourself that can own any sort of property basically in your name. It's almost like a corporation in that sense. There's no annual fees to set up a trust. It doesn't have to be filed anywhere. Some trusts have a separate tax ID numbers, but those are land trusts, and that's not something we're going to deal with today. What we're talking about is a revocable living trust, and we want to think about this as like a bucket that you can dump your property into during your lifetime. And any property that's owned by that trust is dealt with according to the terms of the trust. So it's like a contract with yourself, and you lay out how you want that property handled. And you name a trustee and a beneficiary. The trustee is the person responsible for managing the trust assets for the benefit of the beneficiary. During your lifetime, and while you're mentally competent, you will be both the trustee and the beneficiary of the trust. And so what that means is that your only duty is to yourself. So during your lifetime, you don't even notice the difference between owning assets in the trust versus owning them in your individual name. You have complete control. You can revoke the trust, amend the trust, do whatever you want with the assets in your trust during your lifetime because, again, your only duty is to yourself. If you pass away, you'll have named several successor trustees, people who can act as trustee if you're not able to do so. And you'll also, just like a will, state how you would like your assets distributed upon your passing. You can make specific gifts of your jewelry collection or your gun collection to particular family members, or you can just say, I want my assets divided in equal shares among my children, or however complex you want to get with the beneficiary designation. And then your successor trustee is the person responsible for effectuating those wishes in your trust. So when you pass away, that's when the trust really kicks in. Because, again, during your lifetime, you don't notice the difference between owning things in your name versus owning them in your name as trustee of your trust. But once you're no longer the trustee, someone else that you've named takes over they're kind of like the executor of your estate, and they're responsible for distributing those assets. So that's what a trust is and how it works. We've talked a little bit in our previous episodes about the difference between a trust and a will, so I won't cover that right now, except that a trust does a lot of the things that a will does, but it does some more things. It will keep you out of probate, where a will won't. Even if you have a will, you have to go through a probate case if you don't meet those two requirements of having no real estate or having less than $100,000. So a trust is, it distributes your assets like a will, you appoint fiduciaries like a will, but it also has the added benefit of keeping your estate out of probate. And so, again, once we've created the trust, what we do is we transfer your real estate into the trust by a deed, and we transfer your major savings accounts into the trust. Things like checking accounts and vehicles will usually leave outside of the trust, because as long as you have less than $100,000 outside of the trust and no real estate outside of the trust when you pass away, then everything else is going to get swept into the trust at the time of your death. And I apologize for the ambulance and the trains here. We are on the corner of Main Street and the train tracks in downtown Downers Grove, so sometimes it's like being in the middle of the city here. So what we're trying to accomplish here is making sure that you've got enough assets in the trust so that the assets outside of the trust are less than these threshold amounts that make probate necessary. If that happens, then instead of filing a probate case, your trustee simply downloads a one-page form from the probate court's website called the Small Estate Affidavit. And in that affidavit, they say there's a trust in place, there's no real estate outside of the trust, less than $100,000 outside of the trust, therefore probate isn't necessary. I'm the trustee of the trust, and here's how I'm going to distribute the estate. They don't have to file it anywhere, they just take it to a bank or a lawyer's office to get notarized. And with an executed copy of that Small Estate Affidavit showing that probate isn't necessary because this trust is in place, with a copy of your death certificate and with a copy of the trust, they then have the power to immediately distribute your estate to first pay off your creditors and then distribute to your heirs, according to the terms that you lay out in your trust. And some trusts can basically keep the trustee in control of the assets for, until the kids reach the age of 25 or whatever restrictions you want to put on it. So it doesn't have to be distributed immediately, but anything that you want distributed immediately can be. And most people don't have to hire an attorney to do this. When people call me up and it's a small estate situation, I'll have a free consultation with them, and I'll tell them where they can find the small estate affidavit and how they can go about administering the estate, and say, if you need my help with any of that, give me a call. But most people don't really need our help in administering the estate. So rather than paying 5 to 10% of the estate in attorney's fees, they're not paying anything. And that's why you do a trust and why you do an estate plan. And it's a lot simpler. The third reason probate was bad is that it's a big headache for the executor. Well, the trustee of a trust doesn't have to appear in court anywhere at all. They don't have to file reports. They don't have to provide notices to creditors. They just have to make sure that they find out who the creditors are, pay them, and then pay the heirs. So it's got the benefits of providing immediate access to the assets, much less expensive, no attorney's fees, and it's much simpler for the trustee. So if you have any questions about how trusts work or anything else estate planning related, or about any other area of law, you can call us at 630-324-6666. We do free consultations. You can also go to learn-about-law.com to see a bunch of podcasts, video blogs, and articles on this and just about every other subject. So I'll leave you with this one thought, is that a lot of people think that trusts are for the wealthy. And they think, I don't really need a trust, I just need a will because I don't have a large estate. And that's a myth, because trusts aren't very expensive to do. They're not much more expensive than a will. And they're really appropriate for anyone who owns their home or has more than $100,000 in savings. And usually this is the main vehicle of an estate plan for anyone that's in that situation. And that really, we have a practice in the suburbs, so that's most of our clients. A trust is the main vehicle of the estate plan, and it's much more appropriate than a will. So thanks for listening, and please check out more of our podcasts, video blogs, and articles.